instrument of censure, and which is under challenge. Now, there were, in spite of two directions to file affidavit in opposition, they have not filed any opposition by Coal India. In spite of awarding also cost of rupees 8,500 for non-filing of affidavit. So, my lord, the matter was released by a coordinate bench of Justice Manta because of change of determination. My lord, this matter, if your lordship directs this matter, but this is really for hearing, but if your lordship directs this matter to appear as to be mentioned so that the date can be fixed, and so the other side gets a note. I am mentioning upon notice.
Okay, to be mentioned.
Lordship,
To be mentioned Monday.
My lord,
very good. I'm
Monday
great.
হবে তাহলে আসবে Monday আসবে হ্যাঁ আজকে আসবে ইয়ে করলে Okay, if it's reached the file, it would be listed on Monday, otherwise Tuesday.
Very well. I'm grateful. I'm grateful.
my lord, I beg to mention to one matter, my lord, a ready matter, my lord, higher scale of fame, my lord, covered by Honorable Special Bench Judgment. Let it appear next week, any day, my lord.
Matter is regarding termination of an school teacher.
Regarding
Termination. Regarding a service termination of a teacher.
a hearing matter.
Yes, Lord. That has been heard by Mr. Honorable Justice. Court number.
It was hard,
Yes, Lord.
disposed of.
Yes, Lord. So,
Now, what do you want?
Has been passed an order, my Lord. Then after the determination already has been changed. Then after, my Lord.
That has not finally disposed of, hearing matter.
Yes.
If any application has been filed.
No, there is no application.
Okay, give this.
My Lord, there is another matter, my Lord, regarding service.
Oh, okay, give this.
Item number 70 of today's list. This was heard by your lordship on the last occasion. It was fixed.
70.
My lord. It was fixed yesterday, but it was. My lord. Lordship kindly.
Who is your other side?
My lord, I shall inform Mr. Subroto Basu, Mr. Uttam Bhattacharya, that bank matter. The person who is entitled to the gratuity, that matter which was. If your lordship kindly upraise the matter on Monday.
Monday you inform your other side
My lord, I shall inform.
that it would be upgraded.
My lord.
Yes.
My lord, may I be permitted to mention one matter for inclusion, my lord? The last order was 3rd of.
Where is the slip?
Yes.
Have you given notice?
No, my lord, I'll show
Ebar
notice by today, my lord, to the state, and they were present. They were supposed to file the opposition, my lord, but till now no opposition has been filed, my lord. I shall serve them today by end of the day, my lord.
Yes. Yes, দিন কিন্তু এরপর থেকে করে দেবেন বুঝলেন
I shall serve my lord today.
Yes. Okay.
Grateful, ma'am.
We'll call the list. There is an application.
No.
Application for? There is an application in the list.
No, application is not there. This is hearing.
Yes, can one.
Can one ki jonno chilo go. So that was disposed of long back, madam. Can one ki jonno chilo. Old can. I will doctor.
One proposal was mooted to
Direct
purchase the land directly from the petitioner. Yes.
My lord, that.
So their
My lord, in this matter,
fund has been placed.
my lord,
No, my lord, fund has not been placed till date.
So,
lord,
how
kindly give
long
me-
you will
My
go
lord,
on
kindly
taking
give
time?
me 2 weeks time so that I can take instruction whether, my lord,
Instruction will not order money.
my lord, I know that, but my lord,
You have only mooted a proposal that the land is required to be purchased by way of directly from the.
That is
petitioner.
on 23rd February 2024. Thereafter, they are taking time. Fund is not released. Fund is not released. This is the way.
Who is in possession of the land?
Government. They have distributed to the rehabilitated person.
They have already distributed.
Yes.
So,
According to us, the valuation should be 1 crore 94 lakhs. They have agreed 1 crore 30 lakhs. But insofar, my lord, the last report is concerned, I find they prayed before the authority with the requisition 1,97,000.
1 crore 97.
1 crore 97,000. My valuation is 1 crore 94. They have admitted that I would be paid 1 crore 30 lakhs. Now their requisition is 1 crore 97 lakhs. Well, that has to be paid to me. Let it be expedite, my lord.
So you are agreed to 1 crore 30,000, 30 lakhs. You are agreed.
That was in 2024.
Oh.
That is their agreement. My proposal was 1 crore 94 lakhs because that is the market value.
Yes, what?
my lord, kindly give me 2 weeks time so that I can take instruction. Without
Well,
instruction, I cannot.
instruction will not do. Well, it has to be
I
materialized.
no, my lord.
Now, in every land acquisition matter,
My lord,
you are taking this plea that we have adopted a direct purchase policy.
my lord,
And hence,
but without
give time,
instruction,
give us time, give us time, give us time.
without instruction, I.
If you introduce this policy so that your
My lord,
policy can earn confidence
kindly give me 2 weeks
and
time. So that,
trust from our citizen, you have to take some proactive step.
my lord, kindly give me 2 weeks time so that I can take
It
written
is
instruction.
an exception and departure from the land acquisition proceedings.
My lord,
So you are going to introduce a new policy. So some proactive step is required to be taken so that people can repose his trust on this policy.
2009. Bordorita.
Otherwise,
2007
governments
আমার মামলা করে
will not. Okay.
No.
So they are seeking 2 weeks time. So
My lord, 2 weeks time, I don't have any objection. But it has to be acted upon. My lord, their proposal we have accepted, they requisitioned it. This has to be taken care of. Otherwise, again, they will take time. Your lordship kindly observe that. So that it can be, my lord,
when your
active-
land was taken,
89. My lord,
89.
river eroded persons were rehabilitated in my plot of land with the understanding it will be acquired. Nothing done.
the petitioner has I'm
appearing.
has been initiated as yet, and neither any acquisition proceedings, neither has any acquisition proceedings been initiated as yet, nor has any amount, any compensation been paid. ঠিক আছে, এরকম করে দিয়ে দেন। আমি পেনড্রাইভে দিয়ে দেবো করবো। আপনাদের একজন একটু ইয়ে রোটেশনে 6টা পর্যন্ত থাকলে ভালো হতো না? আর একদিন আপনি থাকুন, একদিন ও থাকুন, সব বলেছেন। পাসওয়ার্ডটা খালি দিয়ে যান আমাদের, আপনারা দুজনে খালি থাকতে হবে, আমরা দুজনের পাসওয়ার্ডটা দিয়ে যান। আচ্ছা ঠিক আছে, আচ্ছা তাহলে আপনারা দুজনের পাসওয়ার্ডটা দিয়ে গেলে ভালো আছে। হ্যাঁ ঠিক আছে।
Your Lordship, I am appearing for the respondent.
Huh.
My Lord, subject to correction, status shows that the matter has been dismissed for default. But my learned friend is
My lord, this is
saying-
the dichotomy. I have mentioned this matter for a not today. At the time of mentioning, when my lord was rising to sit at a division bench, my lord said that my lord has not signed the order on. I just also came to know that it was dismissed for default. The next day I have mentioned this matter.
Now, whether it was dismissed for default?
No, it was not, because my lord had not signed the order at the time of mentioning. My lord indicated that
So I asked you to inform your other side.
my lord, I wasn't aware who the other side was.
It is not proper.
I
You are
was-
junior member of the.
My lord, I sincerely apologize.
Sometimes orally we depend upon you.
Anyway, my Lord,
He said
I understand,
item number 51 and 53.
yes.
However, we missed the word, the 51. 53 we accommodated, we granted, I granted
No,
adjournment.
I understand, my Lord.
But 51 dismissed for default. Thereafter he rushed.
And
I said that I can recall the order, I shall not sign the order, but subject to the condition, you have to inform your other side.
Anyway, that is a
He
miscommunication.
nodded that yes, I shall inform.
My
Court
Lord,
believed that same, court didn't sign the order,
absolutely.
but you.
No, I've informed. This is not my brief actually.
So,
I informed the
Mr.
advocate on
Mitra is
call.
saying so.
No,
That he
absolutely.
has not been
No, he has probably not been informed. I have informed the advocate on record.
Don't do it.
Absolutely not.
Sometimes
Not in
when
my conscience.
I also practice in this court, sometimes when we come as a junior, the court asks you go and do this thing. You bring this advocate. It was not my duty, but court directed. Since I am a junior member, I am standing in the court. At that time, you go and tell that person or a learned advocate that court desire his presence.
I sincerely apologize.
Okay, don't do it. Yes, place your.
My lord, the reason for which that this matter was called was for a direction so that we can restructure, we can retrieve the brief from the judicial records, because we are not in possession of the brief. If my lord's,
It is a disciplinary proceedings. You are challenging the order of dismissal.
yes,
Which has been
And-
affirmed in appeal.
It was affirmed. Dismissal, order of dismissal was affirmed in appeal also.
Yes, unauthorized.
You are a
absence.
unauthorized absence.
Yes.
Okay, you place.
no, the difficulty is why we probably this matter was mentioned was because we had to restructure the brief, because we are not in possession of the brief, the physical brief.
Affidavits were you are.
I am
My lord, I
briefing
can-
this matter without the.
Mr. Mitra can come.
Yes,
to your-
I can, my lord,
Eh,
give a Xerox copy, my lord. If
Yes.
your lordship kindly fix a date, my lord, I can give a Xerox to my learned friend, my lord. I am also interested that the matter may be heard before your lordship.
Yes, so when you
My lord,
Any day next week?
my lord, next week I will be out of station, my lord.
or next week.
Yes, if your lordship kindly takes 9th or 11th, my lord, April
Okay, 9th April.
9th. And in the meantime, let him contact my lord.
Yes,
take a Xerox.
9th April.
And my
Had the learned advocate appealing for the respective.
Yeah, my lord, probably there is a misconception. My lord, another matter I was appearing, my junior Mr. Haldar, prayed for time and your lordship has been pleased to accommodate. Actually, in that matter, the learned senior advocate who was appearing for the ministry, my lord, he suddenly expired. So the difficult, he probably my junior couldn't explain before your lordship. So the difficulty was that the original copy of the affidavit in opposition was
lying
not
with it.
found. So your lordship has been kind enough to give us direction to file the same, taking the Xerox copy. We'll do that.
Okay.
My lord. Great.
Yes. Three.
My lord, this is my application.
And there are two applications.
My lord, I am for the state respondents, my lord.
I am respondent number 9.
9. Oh.
My lord, this is an application for restoration.
Application for restoration.
Another is restoration of restoration.
All are within time.
My lord,
So can 2 is the restoration of restoration.
no.
The can 1.
Uh,
My lord, kindly see order dated 3rd May.
restoration of-
Okay.
Order
I am,
dated 3rd May.
restoration
Kindly
means
see order dated 3rd May, my lord.
I am
main
now
writ petition.
trying to locate according to the old number. Old
Restoration
number and
main
new
petition.
number.
Oh,
1739 is the old number of can
my
2
lord,
and can 1 1700.
can
There are can 3, 4 also
one
3, 4 allowed, my lord.
allowed. Can 1 is yet to be located. Can 1, oh, got it.
can 3 and
এটা কেটে দেবেন একটু
can 3 and 4 have been allowed.
এই দেখুন।
Can 3 and 4 have been allowed.
My lord, kindly see the order dated 3rd May 2024, my lord.
Okay, I am first looking at the can 1 is the dismissal, restoration of the writ petition. And
Can
positive-
1700.
positively can
Can 17.
can 2 is the delay in filing the application for restoration. No, there is no application for restoration of restoration.
No, that has been allowed.
Huh?
Now
So now can 2 is the
1700. Now 1700.
1700. Delay of 2358.
Yes, my lord.
What is your
I filed my
explanation-
opposition,
My
my lord.
explanation is
opposition?
Yes, my lord.
opposition is a composite.
Opposition to the application for condonation of delay or restoration. You have written,
No, affidavit in opposition relates to
yes.
composite affidavit in opposition on merits of the writ petition and also on restoration application.
Okay, what is your
On merits of the writ
explanation?
petition and also on restoration. Question was, my lord, at that point of time, my clerk joined by
Learned
a
counsellor
primary
suffering
school
from various illness could not be able to attend the court. In the last week, as petitioner came to me, the court and made her counsel. Should make inquiry of the
on a clerk to join the primary school education. Although this is evident reply. I took it. This is evident.
affidavit in reply, yes, sir. Only one to the
Evident reply to
reply
the
to the affidavit in opposition to section 5.
the one submission I am making. Section 5. A lot of knows that law, Article 137. Article 137 of the Limitation Act. Section 5 has been introduced in this code, not when we are in this honorable court practice from 1968. Subsequently, it was introduced. Law says 137, Article 137 of the limitation. There is no question of Section 5 BA law. Kindly see Section 5 relates to AP, not the writ petition. It has been introduced, we are following. Introduced by some lawyer, judge is accepting, we are also fighting. Then that is law. Kindly, I am submitting before lawsuit, lawsuit is a eminent judge, whether Section 5 applies to writ petition with regard to continuation of delay of filing restoration application. Restoration application was a more than 3 years. There is no question of limitation. Now it is the discretion of the court whether the lordship exercise discretionary power to allow the absolutely it is discretionary power. Section 5 cannot come into play. Still, we are following.
Or with liberty
judges
of my learned esteemed senior friend.
This
Malad.
is not the
He
law.
has
I have
not
got the
get
judgments.
into
At
this
the moment,
delay.
I am not submitting this.
No, I am supporting my
Let,
senior friend.
let them submit, my lord, then
Not
it is
in- not-
directed.
Do not let us
Let
get
him
into this section 5 all issues, Malad. Kindly allow this and kindly take up the main repetition. Because
It is only
unnecessary
one-
this in the
one
writ petition,
submission.
Malad.
It is only one submission.
That would be my submission, Your Lordship. We shall oppose this matter on merit.
Yes.
But this way,
I am thankful to my learned friend Sarwar.
No, in jurisdiction, some proceedings, code of sections of civil code, limitation act cannot be stated to be directly applicable. Because as per the explanation of section 141, writ is not a proceedings within the meaning of CPC and such and such.
but Malad, rule 53
But-
or 54,
but-
let's say rule.
Such as a writ court has power to review its own. It is an inherent power.
Inherent power.
So the court has some inherent power in the review. In case of belated approach, court has every authority to seek explanation the why you caused delay in approaching this court. Because of the fact, court is always for the person, for the litigant who is vigilant.
Yes.
Court is not for the litigant who is sleeping over his right for the years. So court has the inherent power to look to justify the delay in approaching the otherwise his own pair will be a weak pair, or he is not interested to get such relief. However, since they consider the stand of your respondent,
Restoration,
thankful
Malad,
to my learned friend,
restoration,
Mr.
in
Tharwar.
fact, always it's fault on our part, on the part of the advocates, that we can understand this side, that side. Now we have to explain XYZ, blaming XYZ. I am not getting into this. That should not be our.
since the principle is that if you cause delay in approaching, in taking any action or maintaining any action before any court below, you have to place a sufficient explanation. Sufficiency means reasonable and acceptable.
Your Lordship, kindly allow me to share. That's
So whether the explanation offered in the application is acceptable or not.
Justice R.K. Bagh once said, you have given some explanation. Now, two ways is there. Either you pay to a doctor, get a certified copy, or pay cost to this court. I shall allow. We are not saying anything for law. Kindly allow this.
Okay, yeah, can two turn in, can two. Okay, can two. Can two, it is an application for condonation of delay in preparing the application for restoration being can 1 of 2020. Stop, touch. Heard the learned advocate appearing for the respective parties and peruse the amendments made in the application explaining the delay. And the court this court has also gone through the affidavit in opposition, the amendments made in the affidavits exchanged by the parties, stopped. how, stop. Having heard the learned advocate appearing for the respective parties and on perusal of the averments made in the application for condonation of delay, I am satisfied that the sufficient cause was available which prevented the petitioner in preparing the application within the period of limitation provided therefore. Accordingly, the delay is condoned. The application such and such is allowed. Stop. এবার তলায় লিখুন can. লিখুন ওইটা having heard the learned advocate appearing for the respective parties and upon perusal of the averment made in the application, I am satisfied with the explanation provided towards the absence of the learned advocate of the petitioner on when the matter was dismissed for default.
29th
August 2013.
29th August 2013. ঠিক আছে? Accordingly, the application is allowed. The order dated 29th August 2013 is recalled. The petition is restored to its original file and number.
WP number 10232. W of 2013.
The petition বললেই তো হবে আমার নাম্বারটা কি petition is 29th August 2013. Yes, so now come to the main matter.
Main matter, another day,
Another date.
Another date.
Okay.
Order, Lordship. I will get the.
For their interest.
I am ready to.
Okay.
You
So
guys are learned senior.
list the writ petition for further consideration. List the matter. List the matter for further consideration. When 16th on 16th April.
16. Much obliged.
He lost
Yes.
is one of the eminent judges of this honorable. And one of the most popular judges of this honorable court.
No, it cannot be.
No, it is. It is a fact. It is a fact. Every lawyer, whenever we meet, we always find eulogy of yours.
No. There are many learned judge, many learned. I really read their judgment, reported in various. They are really learned.
Melody, I appear for the
No, I'm for the petitioner.
15 KMDA. On the last occasion, Lordship, kindly have a look the order passed by your Lordship.
My lord was seeking to know that, my lord, whether there was in. Yes.
My lord,
Let me recall. My lord, day before yesterday, my instruction is that some people from housing department as well as KMD has came to our housing premises and they've inspected nothing without notifying us, because we observed that some people were there in the housing and they were making some measurements or not. That is my instruction, my lord.
Process is going on.
Process is
going on.
my lord, kindly have a look. The inspection was held on 2 dates.
Hey, Dintu.
A site plan
My
is
lord, let a copy be served upon my juniors, my lord.
here.
Yes, from your side also many persons are present. A joint demarcation program was held on such and such and also on such and such, 19th March.
By the officials of KMD and the housing department. He has a dispute.
The
with
area is actually bounded and possessed by more or less such and such.
Well, that is the dispute, my lord. The area, my lord, is in dispute. Simple thing, my lord.
এটা ডেটটা ভুল হয়েছে না
Maniktola WC LC means?
মানে that is the women's working
Work come living center, my lord. Because, my lord, at the time when this was a government property, it was registered as a work come living center. That's why living center means LC. Work come living center. Now this is Maniktala housing estate, my lord. But, my lord, the electricity bill comes in the name of work come living center. The ownership has been given 2003.
Lordship will find at the beginning line there is a mistake. I understand, my lord, that pursuant to the letter dated 18th March of the advisor KMD, a joint demarcation program was held on 26th February. That cannot be, my lord, pursuant to 18th March order. There was a separate order, I understand, my lord. 19th March, that would be pursuant to the letter dated 18th March. There is some mistake. One letter, I think.
So actually, the Maniktola housing estate, WCLC, what is the Maniktola housing
My lord,
estate?
my lord, here may I tell you, Lordship, the brief facts.
Maniktola housing estate, what is full form of WCLC?
WCLC means, my lord, that is work come living center.
What?
Previously, the housing estate was known as Maniktola housing estate work come living center. That's why W and LC is given.
Okay. So
previously that was work come living center. Thereafter, in 2003, my lord, ownership process is going on. Thereafter, it has been called as Maniktola housing estate.
Okay. So initially, a quantum of land measuring but comprising an area of 3.97
acre. My lord,
allotted to housing estate.
Yes, my lord, in the Form A, when ownership was given.
And at that time of inspection, it was found that Maniktola housing estate is now in possession of 3.775 acres. So there is a shortfall of 0195 acres. 0195, and there is a playground also.
That
Yes,
is
sir.
So your land has now become converted to a playground.
No. My lord, kindly see. My lord, kindly see. Have a look. My lord, may I simple thing, my lord. My lord, simple thing, my lord, kindly see what is the government has. The page 48, my lord. Kindly have a look to the writ petition 48. I am making it very simple thing, my lord.
Before that, before my learned friend comes to the writ petition, if your lordship once again comes to my report, that what has fallen from your lordship will find
that
the area.
KMD not in.
KMD.
You want, I have.
We have
Now you want to get it.
Ashraya Abasan is on our land. Ashraya Abasan is on our
Yes,
land.
yes. That we are not disputing. We are not disputing.
Number 11 to 15.
My lord has seen the site plan I have annexed.
11 to 15. Let us see, Secretary. Oh.
If your lordship sees the site plan annexed with the demarcation report, lordship
My lord, I am making this issue simpler. My lord, kindly see page 48.
No, actually the inspection was done in presence of your representative also. There was some person on behalf of your representative, and during inspection it was found, yes, there is a shortfall of the land allotted to you initially, but there is a playground and there is a specific observation that the KMDA has not encroached any portion of your land.
That will be evident.
Very well, my lord. I have we have no business with KMDA, my lord. We are housing department. What is our grievance, my lord? Housing department in the Form A appearing at page 48 when giving the, my lord, ownership. This is the registered document, page 48. My lord will find it at page 50 bottom, annexure A.
Okay,
Page-
okay. Before that, yes, surely, yeah, I shall look into that. But you come to your pair portion.
Yes.
Pair portion, the respondent number 11 to 5 in particular, not to encroach upon the area. That petition is initially directed against the KMDA to prevent the KMDA from encroaching upon any land.
Yes.
Any land belonging to you.
Yes. My lord, the prayer at that point of time, what is our apprehension? Why this writ petition was filed? My lord, kindly.
Of the writ petition based on this observation that KMD has not encroached upon any portion of your land.
Yes, my lord, that my lord will record. My lord, my grievance is against the, my lord, my another grievance is against the state government who said initially when registered document, when everybody take ownership, in the Form A they said 3.97. Subsequently, after 6 years, they are saying there was inadvertent mistake. The area will be 3.40 acres. So, my lord, 0.57 acres is the dispute. Now, there is a specific direction of this court, my lord, that was held by Justice Sanjeev Banerjee, March 24, 2014, my lord. That order is there, my lord. There is a specific directions, my lord. My lord, we know what is the prayer of the writ petition and what is there, but thereafter there was an existing order of this honorable court that has not been complied with till date.
Referring my learned friend, that has not been annexed with the writ petition.
But how that will be, that is passed in this writ petition by Justice Sanjeev Banerjee. My lord, kindly see March 24, 2014 order. If my junior have copy, hand over the copy. Do you have?
Okay, so you take copy of this order.
Yes, my lord, I will take exception. I will go through it. I have take instructions so that, my lord, we take an exception to that. If it is acceptable by the housing Abashik Samiti, then it's okay, my lord. Otherwise, they can take exception.
You are here for the state.
I have given
so
both of them.
you are representing the housing department also.
Yes.
Here initially from the it is appearing from the order passed by a coordinate bench that initially initially 3.97 acre land was allotted to the petitioner housing estate. Thereafter it was the stand of the state most probably that no 3.4 acres would be allotted to them and 0.57 acres another project or anything like that. However, KMD interfered in the meantime. The court directed that KMDA, you undertake your project, continue, proceed with the project, but beyond that 3.97 acres of land.
That we have done.
Yes. Now they are saying, now the new report has come that 0.195 acres.
That as per the demarcation held in the site plan,
Now
you will
a
find
new
that,
fact.
that is included in the playground.
Now a
Side
new
plan.
fact that a playground also has
It is
encroached.
used by both the residents of Asraya Basan of KMDA and also the WLC, the Maniktala housing estate, the petition. Residents of both the housing complex are using that playground.
My lord, another thing, my lord, my junior has just now handed over sent me the copy of the inspection report which has been filed. My
Yes.
lord, there is no signature of our office bearers, my lord. That does not contain any, because my instruction is that no office bearer.
No,
Petitioners were not
don't
present.
be so hyper technical.
No. My lord, I am not. I am
You
not.
solve the issue, otherwise
Yes.
this issue will continue. You want to live peacefully in your area.
No, my lord, our difficulty is that, my lord, the housing estate security is at stake because we cannot construct a boundary wall because of this order. My lord, boundary wall, our western side of the housing estate is vacant. And
And you try to be present physically, it would be proper.
my lord, I have broken my leg. That's why I am doing, my lord, virtually.
Once.
I've been operated, my lord.
Jha, Anubhanath, Alok Kumar Patra, who are they?
No, these are the officials of the KMDA and the state government. My lord, the designation is there.
Oh, okay.
Sumon
Yes,
Jha, executive engineer, Anubhanath, they are the executive engineer of CRS. My lord, no dispute. There is nothing to substantiate that the members of the this Maniktola housing, their members were present. But my lord, having said that, those persons who have moved this writ petition before your lordship, whether they are still the office bearers, that my learned friend may be kind enough to indicate.
Yes. Amitabh Gupta, who has filed this, he is the present, he is the present Amitabh Gupta, he then at the time of filing of writ petition, who is the secretary, he is also the secretary now, my lord, who is representing the Maniktala Avasik Samiti. He is the current present secretary of the Avasik Samiti.
Exercise was undertaken pursuant to your lordship's order because on the last occasion I produced a letter dated 23rd December 2024. If your lordship kindly sees that letter with the record, that is a letter issued by the housing department to the petitioner society, as also copied to the KMDA for holding inspection.
Intimation was there.
Intimation was given to the petitioner society also. Then your lordship, after perusing this, when I produce that, what is the fate of that inspection conducted, if any?
Oh,
My lord, yes, intimation was given.
So pursuant thereto, my lord, this joint demarcation was held, conducted by the officials of KMDA and the housing department.
in compliance with the order passed by this court in this petition on 12 March 2025, a report has been placed by Mr. Talukdar on behalf of Report says that KMDA has not acquired or encroached upon any portion of the land.
My lord.
Now, presently, a new story has come that a portion of land has been encroached by some person, and they have converted it a playground.
No, not some person. It is kept.
Oh,
as a
and some of
playground
your
for
members,
both the
some of your
complex.
members have also converted a certain portion of your land to a playground. Okay, you take avail instruction and take decision.
It would be,
My
Milord,
lord.
Ah,
it would not be their land. The government, though it is their grievance, although in the Indian Charter 3.97 has been mentioned, but in effect they were given only 3.52 or 3.6
3.40 initially they said.
initially. Then
Now they are saying
they
that
want the rest of the land.
3.775.
775. So 19 fallen short, which is included in the playground. From the site plan today I have submitted. Plus you will find the dotted portion.
My lord, may I submit one thing, my lord? Only one thing, one innocuous prayer, my lord. Let this report be filed in a form of an affidavit, my lord. This is a court of records, my lord.
Why? What?
Okay, ওপরে লিখে দিন তো report as filed, report as
Yes, my lord.
by Mr. Talukdar is taken on record.
My lord. Then, my lord, give me liberty to take exception to this.
Okay, it has become part of the record.
My lord, and then I'm grateful to your lordship. I'm extremely grateful. I will come back with proper instructions so that matter can be resolved, my lord.
So now the KMDA have not, it is from the report, it is appearing KMDA has not encroached any portion of your land.
My lord.
Now the land shortfall of such and such 0.195, it has been converted to a playground by some of your members and the members of other housing estate.
Maintained by KMD.
Okay, so you take instruction whether you will recover the land from them.
That was not
Or-
given by the housing department as yet.
My lord, the difficulty is that the playground was initially from 1967, there was a playground.
For
Now,
enforcement of that indenture,
difficulty is that, my lord, when I am saying practical difficulty is that there is no demarcation. So how can we demarcate which is what is 3.77, what is 3.97, what is 3.40? Because they have not given the physical demarcation.
you will have to file.
Mr. Tay, now your land has a certain portion of the land has converted to a playground. Now you will take decision whether you will allow them to use as a playground or you will recover from them.
My lord, my lord, my lord, my lord.
Now
My
it is, now KMDA is not in picture.
My lord, my
Okay?
lord.
There will be another difficulty for my learned friend.
Yes.
If he insists upon enforcement of that indenture, then specific suit to be.
Civil suit. Civil suit.
The government
Yes, my lord.
definitely not given.
But problem is
0.9,
that in respect of playground of like nature, whom he will make party.
Yes, my lord. That is another difficulty, my lord.
If any registered club acquire,
I
then you will make party against the secretary and president of that club.
My lord, I had something
But
in
if
my mind.
certain person suddenly into
No, my lord, that is not certain percent because the in between.
playground, they will not play after 10 years. Now a new person come, they will start playing over the ground. Whom they will make party.
Yes, my lord. That is the difficulty, my lord. I will, very well, my lord. I will take instruction. I will proper instruction. I will come back, my lord, to assist your lordship.
Mr. De, I had a suggestion
Proposal,
subject
suggestion,
to
yes.
approval
Yes.
by my lord and also Mr.
Mr.
De.
De.
Let the entire matter be remitted to the principal secretary, housing department, who is the chairman as also the principal secretary. The entire thing would have been resolved, subject to what Mr. De says. If he press on merit, then we will have to.
No, my lord. Let this be done on 22nd April. Let me come up with instruction. I'm open to that, my lord.
Mr. De's client and another housing committee is to sit and have a
They are not a
meeting along there.
They are not party.
They are not party.
Here,
Okay, okay, it is out of court.
out of
They have to take decision whether we shall again acquire the land which is now presently being used as a playground, whether we will do it or we will forego our claim. And keeping it outside the boundary, we will construct one boundary.
because as per their prayer, the housing department is bound to hand over 0.19 acres to them. It is their contention, which since in the indenture 3.97 has been mentioned. To enforce that, writ court would not be an appropriate one. For that, he has to institute a suit. What I am suggesting, the entire matter be the principal secretary, state government, who is the chairman also housing department, the same person holding the two departments can control. The decision can be taken by him. My lord,
Let this order be passed on 22nd April, my lord. If
Take instruction.
My lord, I will take it.
That is in your deed 3.97 acres you committed to hand over them, but practically there is a shortfall and now a portion is being used as a playground. Now what you would be used to, you take step.
My lord, I will take it.
that may be
My
the
lord.
practical difficulty.
Yes, yes, yes.
Since the portion of the land is used as a playground, the government is also hesitating to.
To evict them.
That's the problem.
Yes, take decision.
But it is in fact outsider are not using.
They are also playing. They are also
playing.
they are playing. Okay. Okay,
My lord,
okay.
subject to correction, my lord, then my lord, may I get an humble indulgence? Your lordship can, my lord, only another week extension. Can it be on 29th? Because there are many intervening holidays. Subject to your lordship's, my lord.
Okay, 29.
29, my lord. I am
29 করে দিন।
Great.
Come on 29.
My suggestion, I have communicated to your lordship and also to Mr. De to think over it.
yes, yes, my lord. Definitely.
Yes, yes.
Grateful to your lordship for a patient hearing, my lord.
Yes, yes, please. Next. 5. Yes.
Lordship, the identical matter already earlier occasion fixed, my lord. Learned Advocate General appear in this matter along with other 10 matters, my lord. The petitioner also same. So kindly fix the, as per direction of the Advocate General, kindly fix the month of April.
The PH department with the understanding taken over the possession of the petitioner's land in 2009, saying that there will be on employment in your family. These are all my lord and the land compensation will be granted. And we have granted the consent to the department.
Based on this as well. Oral as well.
It has been constructed. Now in 2015, the project got started. When I approached this honorable court, because I have been defrauded by the authority. I have not been paid compensation, not even given any appointment. On appointment, this cannot be said appointment, contractual appointment under an agency. I have been debt. But insofar the compensation is concerned, in this concerned matter, there was a direction by the honorable court, since they have agreed to direct purchase, saying that you obtain the valuation, government valuation, and I agreed to that, saying that as per the government valuation, I am eligible to sell it. Now, your lordship, kindly peruse my supplementary. This is the government stand. In the government stands, they have ascertained their valuation. Supplementary. Annexure, first annexure, page 3.
Okay, I couldn't find it. I couldn't find it as a supplementary evidence is. Yes, got it.
Since petitioner was implemented by the executive engineer, but page 3 is supplementary.
Yes, they have collected the valuation report. Valuation report from the district register or sub-register.
Valuation was ascertained by them. I am agreeable to that and supplementary evidence I have conveyed my concept. Well, only that has to be executed. For that reason, AG will appear the matter.
Earlier occasion,
Seven
earlier occasion already fixed the matter along with the 8 matters, my lord, same identical matter.
Absolutely not. Absolutely not.
Yes, yes.
These are
Earlier, kindly see the order sheet, my lord. Earlier occasion, learned advocate general appeared in this matter along with others matter. Kindly fix.
never appeared in this matter.
Lordship, kindly see the
On 8 January 2024, before another coordinate bench, Mr. Dr. appeared.
Lordship. Along with others matter, my lord, identical. Kindly fix any date matter in the month of April as per directions of the learned advocate general. Along with others petitioner, kindly fix. Yes, yes. Same identical matter. Same identical matter. Same identical matter along with 8 numbers of the same identical matter appear by the learned.
Regarding the land of same area,
Same.
how many land they have utilized in this way? In your area? In that area?
In this petition, they have constructed.
I know this petition has
Let them argue at that time along
has
with
a-
others matter.
Oh, this petition has a separate cause of action. Okay. Court want to know how many land of that area has been utilized by the state in this fashion.
Well, area means
In your area, in which this
my area or this is my plot. In
so why are you saying?
this is
There is no reflection in the order that a similar issue is involved in any other petition. There is no.
in every
So there is no question of analogous hearing or anything like that.
Earlier occasion, a petitioner knows very well, my lord.
valuation has been ascertained by them. I mean, to that. Let it be executed.
Lordship, kindly see the order dated 1912,
1912.
24.
Okay, Mr. Mondal and advocate on the submits for listing the matter also where other petition are listed to appear dealing with similar point of law.
Already considered, my lord. Let them others matter appear.
When that has been fixed, that matter
That is not the state. This was in the list
At that time was fixed on 8 January. Then second date already fixed.
Whether
Lordship kindly fix the 8th date.
whether any date has been fixed by this court.
At this stage already fixed, but not yet final disposal. So kindly
Whether
kindly
the
fix
writ petition involving the similar point or issue is pending before this court.
that was fixed on 5th.
So how can I say fixed?
Earlier occasion for the same identical matter.
and ascertain in this matter only. Your lordship can fix this matter any day. Let the advocate general come and specify.
All others matter, he is also the petitioner, my lord.
2015 matter.
That is not before this court. Maybe it is pending in another court.
Many matters I am not interested to do those matters. This matter I am interested. It has to be done. Why this is on the way? I don't.
Lord, sir,
find
as a
any
director, kindly fix the date of fixed in the month of April, my lord. Others matter or that matter. Kindly fix as per directions of the. Yes, my lord. Other matter, advocate
Let the
general.
advocate general whoever
Fixed, fixed on April, my lord. Any date.
When you have utilized the land,
2009.
okay, I am fixing according to your choice. You go on paying rent compensation.
Yes.
How much land? What is the?
It will be disputed, my lord. It will
33 decimal band.
It will disputed, my lord. It will disputed, my lord. So at this stage,
It is submission from the bar.
So
Submission for
at this stage,
submission for the bar.
for the interest of
Mr.
the state,
Mondal,
my lord,
Mr.
Advocate General appeared in this matter, my lord. Kindly fix any date, my lord.
Maybe. Don't say the name. We consider about the merit, not about the person.
Lordship, for the interest of
Okay,
the
if you think about the
earlier
person,
occasion,
we
advocate
shall not be able to decide any issue. We are just concerned with the merit.
all the papers and records.
With due respect, I am saying that come to the merit. Don't show any person or such and such. Merit will not be varied due to the appearance.
Lordship,
Monday will not be
Lordship,
Tuesday.
kindly fix any
If any person
particular
appear,
matter, kindly fix.
okay, Monday would be Monday. Red would be red. Okay.
Lord, kindly fix the any date, Advocate General will appear in court.
You are not following the code. That writ petition involving the similar issue not pending before this court. First.
That was not mentioned.
Okay. So this writ petition has come alone, has been mentioned. This writ petition has been placed in the list alone. So no other matter involving similar issue is pending before this court.
Lordship, as your lordship discussion,
So this court has
as
got
your lordship discussion, my lord, in this matter.
no discussion. It got this court
In
has
this matter, kindly fix any date, my lord.
okay. Tell me. Give the money. Give the money. Yeah. Give the money. Otherwise, court is to would be forced to pay direct to pay the rent compensation.
There is,
Okay.
in the meantime, there is
you,
dispute as
okay,
regards
go on
the
paying rent in
as regards
compensation.
titles of the land, there is no any dispute. So it is the state is bound to pay the.
No dispute that you have acquired, you have taken possession of the land. Maybe you have a eminent domain power, but you can duty bound to pay as per Article 31 B, C, whatever 300A of the Constitution of India, following the due process of law. Okay, you have got a eminent power to take land of any person, but following the due process of law. You follow the due process of law, then you do exercise your eminent domain power. Otherwise, court will take out its long arm, okay, to decide the issue. Okay, when you tell on which date shall fit, but on that date, you come with definite stand. Otherwise, the court will be forced to direct to pay rent compensation. Whether you will, in view of your direct purchase policy, you will directly purchase from him. If you want, purchase. Otherwise, pay compensation as per the present law. As per the existing law. 8 April will be proper. Take in another matter I have said that you have time to introduce a direct purchase policy, but people will not repose or any faith on you if there is no consistency in your action. But you have to come with definite stand. That yes, we are going to purchase the land directly from the petitioner, and this is our document. And we shall need some more time. In the meantime, we shall go on paying rent compensation. You cannot do so in this way. Tell. I shall fix according to your 8 April, and I shall record it. 8 April. 8 April? Okay. Mr. Mondal, learned advocate, repenting the petitioner pays for accommodation to avail necessary. Hmm. You are terminated or dismissed? Removal after disciplinary proceedings? Okay. There was any appeal? Of fake certificate during probation period or after confirmation? After confirmation, appeal paper. Oh, after 11. Yes. Direction for affidavit was given. But affidavit in opposition. Affidavit in opposition is not with the record.
He has been served the copy. I have prepared the reply. I have served the copy. So, output of the copy is available for the.
So will you place it today or it will keep it and on the next day?
I shall give this to him tomorrow and keep it on next week.
Any order is required to be better petitioner already taken. Okay. ডেট দিয়ে দিন তো একটু সামনের সপ্তাহগুলো অনেক বেশি হয়ে যাচ্ছে আসলে নেক্সট সপ্তাহের জন্য না অ্যাডমিটের সামনে it would be better if 21 or 22 because in the coming week there is a explosion in the docket. Okay, 21 you give a notice. Next.
For the petition.
Yes, there is an application.
Application for expeditious hearing, my lord, that has already been disposed of by lordship probably on the last day.
My lord,
Don't pray for adjournment, you do it.
My lord, the petitioner before your lordship. It is a
You do it. It is the opportunity to open your mouth in the court. You will say, what shall I do? Court did not grant adjournment, and hence you will say it to your senior. Okay.
My lord, it was for DPSC. My lord, I am not in the panel.
Okay, you do it. Your senior is in court today.
Yes.
Oh,
Yes, my
okay,
lord.
you do it. Don't.
It is a 2006 selection process, my lord, 2017 writ petition. In the meantime, certain reports were also, my lord, were on the surface. In the opposition, in the writ petition, my lord, specific allegations in paragraph 9 and 10, my lord, will be, my lord, dealt with, should be dealt with by them. But their opposition, they have avoided. My lord, kindly, this is a report given.
9 and 10.
Paragraph 9 and 10 of the writ petition.
What is his claim, his allegation, the petition?
Allegation, massive illegality in conducting the said selection process. Even the persons not in the panel have been given appointment. Even the inquiry report was conducted by the a team of director of school education, and they had given a report. Lordship will see. I have annexed the report. The cream of the report, paragraph 9, I have said. The total vacancy has been shown in page 2 of the report of DAC is 2047. But as per communication of the District Primary School Council on 22/2/2010 under memo number 2021, the total vacancy was shown as 2065. In addition to that, 20 vacancies were earmarked for Hindi medium. No answer has been given as to what happened to those 18 vacancies in the said report. By another information supplied by the Labour Department, Government of West Bengal to one Alok Chakdar, copy of which has been supplied by said Chakdar to the petitioner only on 7 September 2015, it appears that only 1626 vacancies were notified, including 20 Hindi-speaking people, by the said Paschim Midnapur District Primary School Council, although by letter dated 22/2/2010, 2665 vacancies were allegedly notified. C. One Ongshuman Bhuya has been given appointment in 2006. Selection process only employment exchange sponsored candidates were appointed. From exchange, Madhyamik pass candidates were called as per the seniority list in the jail category up to 1988, who were so registered with the employment exchange up to that date. Ongshuman Bhuya passed in 1991. As such, he was not supposed to be registered with the employment exchange in 1988 as a bona fide candidate. Hence, his appointment cannot be said to be valid, nor he could be said to have been sponsored by the employment exchange. D.
This matter, also comes, I am for the petition. The report for the content of it. Allow me to sample one thing for the betterment of our learner. It was properly wrongly advised, or properly not properly advised. My learner is wrongly advised. In this matter, petition number 677, not appearing to the examination selection of the I think is a better way. I know. But
No, one thing.
I can assist my learned friend. I have no problem.
One.
Ordinary petition. On the basis of which came another yes.
That was the first petition, the father petition. That was the mother petition originally. Advaita Bera, my learned friend, is a very prudent man on the subject, and he initiated that proceeding. But somehow,
One thing. Here the petitioner is Sandeep Chakraborty and 7 others.
Yes.
So whether you are representing them in this petition.
Betterment for the party, betterment for the London, betterment for the court. Right? The petitioner hearing by London Court, London.
My lord,
They are baby there.
no.
They are baby. They are baby.
My lord, may I submit? The petitioner
6 and 7, Rahul Chakraborty.
Rahul Chakraborty, petition number 6.
Dilip Kumar Odhikari.
Sir, he was.
They are minor.
Rahul Chakraborty was.
Yes. 2006. They are baby now. 8 years, 7 years. 8 years, 7 years.
oh my God.
My lord, 11 years.
Yes.
11 years boy, given appointment.
My lord, 11 years. Rahul Chakraborty was 11 years.
8 years.
At the time.
At that time.
11 years and
these 2 persons even appear in the sentence. Neither in the representation nor in the representation.
And 7 also.
7 also.
What is your age at the time of? What was your age at the time of?
Yeah. That's important. Well. 2006 But was appearing for it. 2006
So whether still you represent this 2%?
But he is saying something on air. Nothing is on record to me.
Who is your advocate on record? Where is your Bhokaratnama?
Anupam Mondal.
Anupam Mondal is your advocate on record. Anupam Mondal. Yes, Rahul Chakraborty and Dilip Kumar
This has not been
Odhikari.
taken even point in the opposition.
But the signature are almost same, written by the same person. Oyonbag, Rahul Chakraborty, Dilip Kumar Odhikari and Pradip Kumar Chakraborty, this signature has been made by the same person.
Bhokaratnama?
Bhokaratnama.
I have not checked that.
So you produce this person. What can be done? Whether
Yes. I directed the court, wanted them to be present before the court.
Yes. What can be done?
Affidavit has been made by the Rahul Chakraborty.
Affidavit has been made by the Rahul Chakraborty.
Rahul Chakraborty.
Rahul Chakraborty claiming himself to be of 19 years on 2017.
Yes. 2017, 19.
When the election sticks.
Election process was initiated
So-
held in 2009. Held in 2009.
2006 January both 18 years.
I have not said that I have participated in the selection. I have said the massive illegality has been detected by the different authorities. Still, the panel has been maintained by the district primary school council.
What Lucas Tanda you have got?
I am an aspiring person, Malat, for taking employment as an unemployed person. Are desperately trying. If this panel is cancelled, new startup will be there. I can participate in
And
such selection.
Court has a suspicion whether this person actually executed Vokalnama in favor of Anupam Mondal or not. Because signature is also almost same. Same person,
May I
same.
look for one?
Why not? You just see the last four signature. Last four signature, same pen.
My lord, there is a report by district DPSC Paschim Medinipur. It says that the petitioner number Rahul Chakraborty, who was affirmed in the writ petition, passed Madhyamik examination in the year of 2013. So at the time of the written test, his age was 11 years. So there is no question to participate in the examination. So there is a report.
I have not said that I have participated. What you have find the report? I have not participated.
Raise the petitioner participated.
Yes.
Appears to be the same person as signed it. As is Malat. Actually, was a better I.
So I am directing them if situation so demands, I can transpose them as respondent in this petition, and whether they executed Vokalnama in their favor or not. And I can transpose the respondents, and I can also seek explanation from them that if they are appointed, why their appointments shall not be cancelled.
My lord, may I kindly submit this report?
My lordship is putting the question in respect of Rahul 6 and other.
Rahul and Dilip Kumar Odhikari.
Rahul and Dilip.
And this allegation has come, but Vokalnama, you see whether they executed this Vokalnama or not. Court can ask them to write in presence of the court.
They have also filed an application for take part in the interview in 2016. Where Rahul Chakraborty, petition number 8, it had appeared before the Gangawal. My lord directed them to appear.
2016, he was more than 17 years.
Yes.
He was 19 in 2017. Therefore, he was 18 years in 2016.
No, 2000, when the selection process
He is wanting that I have applied in 2016. Give me.
Oh, no.
That is nothing. That
Achha, the
time you have
present
made up.
petition has been prepared by 8 writ petitioner, 8
persons.
8 writ petition, citing some irregularity in the selection process. ঠিক আছে? Initiated in 2006.
Well, before your lordship concludes, what should the locus of my Nanak to interfere? He was not. He is no man here.
My lord, kindly see the report.
No man here.
in this matter?
I am ready to assist your lordship.
Okay. If court finds that your presence would be is required, would be required. Okay. Next.
Grateful, my lord.
I'm for the petitioner. Lordship, I'm not pressing the application and this is my written.
Any written instruction? Yes. Laneta, what's your name?
Shipra Shatra.
Ms. Sachansai Laneta, advocate defending the petitioner, submits that the petitioner does not want to proceed with the petition. Stop. Written instruction as produced by Ms. Saha is taken on record. Stop. In view of such submission made on behalf of the petitioner, the writ petition stand dismissed as dismissed for non-prosecution. Any interim order? There is any interim order?
Grateful, Lordship.
Yes. Item number 9. এই 9 টু যে এটা সেম আমি যে দেখছিলাম 9 থেকে একদম পুরো 27 পর্যন্ত আমি সেম অ্যাডভোকেট
9 থেকে না 10 থেকে
না 10 থেকে 9 ও 9 who is for 9 okay 9 not today নিচে নামিয়ে দিন bottom of the list
10, my lord, I am for the petitioner.
10 to 27 I was speaking.
Your lordship, my lord.
It is similar matter.
Yes, similar matter. My lord, these matters are relating to they are contractual whole-time teachers of college. We are paying equal pay for equal works pursuant to the Jagjit Singh judgment and by our division bench affirmed by the Supreme Court. My lord, but I must tell this to your lordship, my lord, it is my unfortunate that a similar matter is being heard by a coordinate bench and the same has been made hard in court. But I have
so I am releasing this matter.
Well, I have no problem, my lord, but being an officer, I am
No,
it
no,
has not been concluded. Only hearing has started, my lord, before the coordinate bench. Hearing has
It
started.
has been made hard in part.
Hard in part, but not these matters.
Okay, okay, similar issue.
Similar issue, my lord. This is the order.
My
lord, this is the order. Order take. My lord, only one thing, my lord, subject to your lordship's correction. My lord, these matters are being heard. Your lordship kindly adjourn this matter for 3 months because it will again not be listed this court. If judgment is passed in those matters, I will mention so that it can be disposed of. My lord, your lordship will release again, it will be assigned.
No, no, yeah, don't. If it is not taken up by this court, you will mention this matter. But I am to wait.
Yes, yes,
I am to wait.
kindly keep this-
First, a coordinate bench has already applied its mind and made the matter part. So the court has substantially half that matter. And now another coordinate bench should not be. There may be conflict of decision and.
No, that is why I am saying your lordship kindly adjourn the matter, not kindly.
No, actually, it would be don't worry. In my report, you just say and it would be included. I am liberal. I am not so strict that I shall not include any further matter in the list. No. আচ্ছা আমি এইটা একদম আইটেম নাম্বার 10 থেকে আইটেম নাম্বার 27 পর্যন্ত আচ্ছা মিস্টার ব্যানার্জি লার্নেড অ্যাডভোকেট
Mr. Dasgupta,
মিস্টার দাশগুপ্ত সরি মিস্টার দাশগুপ্ত লার্নেড অ্যাডভোকেট representing the petitioners in all those matters submits that a writ petition involving similar issue has already been heard by a coordinate bench of this court, and the said writ petition has been made part. Stop. Has been made part ছাড়া আর কি বলবো উনি তো বলবেন let the matter treated as a part. The said matter has been marked as part করে দিন তাহলে ভালো হবে has been marked as part. করে যাবে। বুঝতে পেরেছেন? এইবার সমস্যা হয়ে গেল। কারণ মানুষ এত ইয়ে করতে পারবেন যে এক ঘাটে 10 থেকে 27 পর্যন্ত হয়ে যাবে। এবার এইখানটা দেখবেন লোক থাকবে। ডাকুন আর কি। আর 28 ডাকুন। ও নট টুডে করে দিন আজকে, দুটো থেকে দেখে নট টুডে 29 নট টুডে। হ্যাঁ, সেম। ইয়ে হয়ে গেল, বেকার হয়ে গেল।
At number 40 and 41, I am paying for not today.
Not today, yes. From 2 and onwards, I have a different bench. Whether not today করে দিন আর কি, জাজমেন্ট গুলো দেখি বসে বসে গিয়ে। হ্যাঁ, 70টা বলছিলাম। 74 with 75, 76 এরকম করে বলতে হয়। হ্যাঁ, উইথ বলতে হয়। নট টুডে আর কি, এখন হ্যাঁ। হ্যাঁ,
For the petition.
yes.
Well, this is relating to appointment in a Christian minority institution in South 24 Parganas. Malada, rejection of the candidature of the petitioner has been done on the ground, only one ground. Lordship will kindly look at that he was having 1 year B.Ed. One year B.Ed course.
Oh.
1 year B.Ed.
That dispute, 1 year, 2 year.
Yeah, 1 year, 2 year, that issue. Now, we have ballot in the petition, in the writ petition, annex the government order and all the UGC notification showing that 1 year B.Ed course is valid. Accordingly, we made the representation to the, in the writ petition, we have agitated the said issue. Maharaj, I would be obliged if your lordship relegate it to the authority, that district inspector of schools, to reconsider the issue on the basis of the submissions made by me in the writ petition.
No, we are to be court is to be satisfied because of the fact subsequently the beach course was introduced, most probably beach course and many things.
My initial appointment,
NCT has done many
NCT
matters.
notification I have annexed here. NCT notification affirming that 1 year B.Ed course is valid is already annexed in the writ petition.
Okay, who is your other side? So give a notice, I am trying to assist you. One Samol Mukherjee for Union of India and Mou Saha for respondent number 456.
Mala, I have, sorry, Mala, my item was 67, not 87.
Oh, 67. So it are not good. 67.
Well, kindly
Okay.
take up for 167. See, no one is getting prejudice for that. No one is coming. I shall only prima facie satisfy your lordship.
Okay, 67 একটা next week এ দিয়ে দিন তো।
দেখান তো।
একটা next week এটা 67 টা upgrade করে দেবেন। You
হ্যাঁ।
just give notice to your other side. That
Yes,
it
I
should-
shall give notice.
It would be upgraded. It was mentioned the matter will be upgraded.
Monday.
Monday তাহলে Monday করে দেবেন নাকি? Monday অনেক matter আছে।
Then Wednesday, make it on
Wednesday.
Wednesday করুন।
হ্যাঁ, Wednesday করুন। Wednesday এটা রেখে দিন। ঠিক আছে?
Grateful to lordship. No one is here, lordship. Such a
No,
bench.
No, it would happen because of the fact Mr. Dasgupta had included your 10 to 27 matter. But at the time he said that similar matter has been heard by Justice Joysen Gupta and make it part. So I released the matter.
What is the issue?
I have not applied my mind.
College matter, definitely.
And hence the advocate will not be able to anticipate that from 10 to 27 it would be adjourned. The next গুলো ডাকো।
85 টা ডাকুন না, অংশুমান দেবনাথ। That also may be upgraded.
85 টাও আপডেট করে দিন তাহলে ওই দিনই করে দিন। হ্যাঁ, you give notice.
I shall give notice. I have already given. Gaurav Das has been given notice.
No, it would be upgraded. Yes.
আর কোনটা এটা?
89, 88.
I am for the petitioner in 90.
90 also.
I am petitioner.
Okay, এটাও আপডেট করে দিন একটু, but it would be on the same date.
Thursday.
এটা Thursday করে দিন।
Then Wednesday, man, keep it on Wednesday.
আচ্ছা, ঠিক আছে, on that date update. You give notice.
Yes.
91. তাহলে যাই আজকে আর কি হবে। না করবে আস্তে আস্তে করবে। আজকের দিনটা একটা প্রেশার দিচ্ছে। আজকে আমার ওখানেও দুটো থেকে যা লিস্ট আছে থাক, কোথাও নামাতে ক্ষমতা না। আর যারা আপগ্রেডেশন চাইছে দিয়ে will you say something? Nothing has been made not today. It will be written in the list on Monday. Don't worry. Okay.